reaction to Sydney Park's passing. Isn't that right?
I'm aware that.
Objection, Your Honor. This is the same, essentially the same question. He's asking to elicit the same content.
Your Honor, you asked me not to go ask what she was aware of. She's aware that there was a reaction.
The witness can discuss what she observed.
Your Honor, if I may clarify, he's not asking her to describe what she observed, just what she read in someone else's affidavit and what they saw and observed.
Your Honor,
and heard.
may I respond? All experts in the are never physically are in the situation in which they are hired to make an opinion on. The experts then rely upon sworn affidavits and evidence to come to their conclusion. Rule 703 states that if that piece of evidence is more probative than prejudicial, then it's admissible. Now, the prejudicial effect with this is being substantially outweighed by the probative effect. The probative effect being that this witness's conclusion is being rebutted.
Mayor, I objected to hearsay. Opposing counsel responded that it is more, under 703, it's still admissible because it's more probative than prejudicial. However, the image of a child crying and weeping over a dead body is substantially more prejudicial than probative. It's not substantially more probative than prejudicial. These statements are still inadmissible and do not truly inform the jury on anything, especially here considering that she's just testified that psychopaths can be incredible at lying and mimicking whatever emotions they feel are necessary for self-preservation.
Yeah, this goes into the underlying facts and data that this witness relied upon. I asked this witness if they reviewed the affidavit of Terry Chapman. And from reviewing Terry Chapman's affidavit, she was able to come to the conclusion of scoring Jesse a 1 on the lack of emotion to the pain of others. Now, this line of question goes to rebut that part of the witness's conclusion in today's case. And for that, it's more probative than prejudicial.
The rule that you're referencing, 703, an expert may base an opinion on facts or data in the case that the expert may have been made aware of or personally observed. Even if those underlying facts or data are not admissible in court, the opinion may be shared. I don't have a problem with her opinion being shared. The specific underlying facts and data may be heard by the jury, even if they're inadmissible, if they are substantially more probative than prejudicial. This specific instance of Jesse crying does not meet the burden, does not meet the standard of substantially more probative than prejudicial.
Your Honor, opposing counsel only read the former half of that rule. The latter half says, but if the facts and data would otherwise be admissible, the proponent, that being myself, of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate that opinion substantially outweighs the prejudicial effect. And that probative value is rebutting the expert's conclusion. And it's important for this jury to understand the underlying facts and data this expert used and come to the conclusion. This expert is calling Jesse Duran a psychopath. Hearing that he exhibited symptoms contrary to the ones that a psychopath would exhibit, it's more probative than prejudicial.
I'm going to overrule the objection.
Yes, Your Honor.
Now, just to be clear for the members of the jury, you reviewed the affidavit of Terry Chapman.
Yes, I did. That was one of the many pieces of information I used.
Terry Chapman was the first person to walk in that home when he heard the gunshot on August 18, 2010.
Yes.
Terry Chapman asked Jesse what happened.
Yes.
Now, when asked Jesse what happened, Jesse began to cry.
Well, Your Honor, excuse me, but the question about the crying was specifically, I had an objection about it earlier, which was sustained. He was allowed to ask, though, that there was a reaction. The specific crying was, what was he saying?
I'm going to overrule.
Yes, Your Honor.
Jesse began crying.
When Terry Chapman first entered the home, he describes actually
I'm sorry, Dr. Couples. I'm asking what happened after Terry Chapman asked Jesse what happened. Immediately after that question, Jesse began crying. That's true, isn't it?
Jesse only began to cry when he was asked the question.
In fact, Jesse began covering his face.
Once he was accosted by Mr. Chapman, yes, he began displaying emotion.
He was saying how Terry Chapman describes Jesse as looking afraid.
Terry Chapman originally described Jesse as being almost startlingly emotionless, but once asked a question, he did began displaying the
Dr.
motion.
Couples, is it your testimony today that after Terry asked Jesse what happened, he was looking that way?
No, what I said a moment ago was that initially he was described as emotionless, but once asked the question, he began displaying emotion.
Just to be clear for the members of the jury, when asked what happened,
Objection, Your Honor, asked and answered. She has answered sufficiently, given a yes and no in her short explanation.
I'm going to overrule that.
Yes, Your Honor.
after being asked what happened, Jesse covered his face.
Once asked, yes.
I want to move on, Dr. Couples, to another trait that you evaluated Jesse with, and that's persistent aggression. And you gave Jesse a 2, right?
Yes, because nearly every source that I examined described instances of Jesse behaving to a degree of aggression that was unusual in someone his age.
Well, I want to be clear for the members of the jury. When you scored Jesse a 2, that means that the trait clearly applies.
Yes, as I said, it was apparent in nearly every source I consulted.
Well, had one source stated otherwise, then that would mean sometimes or somewhat present.
Well, no, not exactly. If one source out of the, I believe, around 15 or more that I examined, that would not have been enough to disprove it. 14 out of 15 is still enough to say that it strongly applies.
Well, I want to talk about that one source, Dr. Couples. You reviewed the affidavit of babysitter Danny Brooks, right?
Yes.
Now, Danny Brooks babysat Sydney and Jesse throughout the entire summer of 2010, right?
Well, Danny Brooks was Sydney Park's babysitter and on occasion also supervised Jesse Duran.
Over the entire summer.
Yes.
Now, I want to be clear for the members of the jury. In Danny Brooks' affidavit, which you reviewed, mentions no times where Jesse would put his hands on Sydney.
That one affidavit did not, but the overwhelming weight of the evidence did.
During that summer, Danny Brooks saw Jesse. Jesse never kicked Sydney,
No.
never punched Sydney,
No.
never even threatened Sydney one time.
Not as far as Danny Brooks knew.
Now, in fact, one specific instance, Sydney actually pushed Jesse on the ground.
I believe that's true. Any child, as I said, pushes boundaries and acts out on occasion.
And for Jesse Duran, who you believe to have persistent aggression, Jesse did not hit Sydney back.
On that one isolated occasion, he did not display aggression.
Dr. Couples, you are hired by Ms. Park for this case. That's correct?
Yes, that's true.
She hired you with the intentions of helping to prove that Jesse deliberately shot her daughter?
No, not exactly. She hired me to determine if he suffered from any psychological disorders that would explain the behavior.
Is it your testimony today that Ms. Park did not hire you with the intention of proving that Jesse deliberately shot her daughter? Yes or no?
Objection, Your Honor. This question asks my witness to speculate as to the exact intentions and mindset of Andy Park.
Your Honor, during the moment in which this expert was hired, she can testify whether or not she heard Ms. Park make any statements about trying to prove or disprove anything.
May I respond? That's not what the question was. She's already testified to what she was told and what she intended to do with her investigation. But this question is asking my witness specifically to testify to what Andy Park's intentions were.
May I respond, Your Honor? We as the defense counsel, we're not trying to say whether or not Ms. Park did have that motive, but the effect on Dr. Couples and her credibility. And that is why the question is being asked.
Was that a response to hearsay?
You objected, counsel, to speculation. Rule 602, need for personal knowledge.
All objections are directed towards the judge. 602, yes, I objected under lack of personal knowledge. My witness doesn't have any knowledge to the mindset and intent of the plaintiff here, Andy Park. That's what the question was asking. The opposing counsel should ask my witness, what were you asked to do in this investigation? Not what did Andy Park want? What did she intend? Why did she call you?
Your Honor, again, we don't care whether or not she had this motive or not. It's the effect on the listener and and this goes to attack the credibility of this witness.
I'm going to overrule.
Yes, Your Honor.
Dr. Couples, from when you were hired, Ms. Park told you that she wanted your help in proving that Jesse Duran deliberately shot her daughter, yes or no?
I don't believe that can be answered with just yes or no. I was hired to determine if he suffered from a psychological disorder.
Your Honor, let the record reflect on approaching opposing counsel with expert's report.
Which part are you going to use?
1.2.
All right, go ahead.
Your Honor, may I approach the witness?
You may.
Dr. Phelps, I'm handing your expert report. It appears to be a fair and accurate copy.
Yes, it is.
You recognize this as in the same condition as you submitted it in August 5th, 2014, am I right?
Yes.
You knew you had up until today's trial to make any changes to that report.
Yes.
And in your report, you told us that you were told to be complete and truthful when making this up, right?
Yes.
And you have complied with that obligation.
Yes.
I want to turn your attention now to the latter portion of paragraph 1.2. The attorneys told me that the Parks disagreed with that decision and wanted my help as a part of an effort to establish that Jesse deliberately shot Sydney. Did I read that portion of your paragraph correct?
Yes.
Your Honor, may I approach the retrieve?
You may.
After being hired, Dr. Couples, you were paid $46,000 for your work, right?
Yes, as any expert, I was paid for my time.
After being deposed, you were paid an additional $10,000?
Yes, I'm a full-time professor and I need to be compensated for being away from my work.
Once finding out that you had to testify, you were paid an additional $10,000.
Yes, appearing in court is quite labor and time intensive, and I was paid for my time and work as an expert.
Also, you were being paid for travel expenses?
Yes, I live and work in Iowa, and the trial is taking place in the Midlands.
To be clear for members of the jury, you're being paid $66,000.
Yes, as any expert, I'm compensated for my time.
Paid by Miss Amy Park.
Yes.
I have nothing further.
Give me your redirect.
No, Your Honor.
Call your next witness.
Your Honor, the plaintiff would now call Joel Sebastian to the stand. Good morning. Can you please state your name for the court?
Yes, my name is Sebastian, Joel Sebastian.
And where are you currently employed?
I am currently the lead forensic investigator here in Breckenridge County. I lead a team of 3 other assistant investigators.
Have you had any other jobs in the past?
Yes, prior to becoming lead forensic investigator, I was also an assistant forensic investigator for 12 years.
Can you give the jury some of your educational background?
Yes, I obtained my undergraduate in criminology for the University of North Carolina, Charlotte, before pursuing my master's in forensic science. I also graduated second from the police academy.
How many crime scenes have you conducted?
Yes, I conducted over 212 crime scene investigations, and I was supervisor for 58 other cases.
Now, I want to talk to you about the events on August 18th, 2010. Did you receive a phone call that day?
Yes, Around 10 a.m., I received a phone call from Officer Williams.
What did Officer Williams tell you?
He told me that a forensic investigator was needed at the scene on Maple Street. And so I went there and I arrived 20 minutes after.
And whose house did you go to?
I went to, well, it was brought to my knowledge that this was the Park residence. So I went over to 20-something Maple Street.
What was the first thing you saw?
Well, when I arrived on the scene, I parked my car on the street and I was greeted by 2 EMTs. They explained to me that there was a body inside of a little girl and that they weren't able to move it or touch it. And then I proceeded to enter the house on the west wing.
Who did you later learn that this girl was?
It was brought to my attention that the young girl's body was Sydney Park.
Did you collect any evidence at the scene?
Yes, while at the scene, I took several photographs, specifically of the position of the body. I also collected fingerprints from Terry Chapin, Jesse Duran, Andy Park, and Sydney Park. I obtained my fingerprints from Sydney Park at the autopsy the following day.
What did you do with these fingerprints?
Well, I performed a fingerprint analysis.
Can you explain to the jury what fingerprint analysis is?
Yes, it's kind of tricky. Fingerprint analysis is using points of comparison from a known origin and the unidentified object in question, and using these points to declare something a match. Me being a forensic investigator and other scientists in my field declare 16 points of similarity sufficient enough to be a match. However, others go higher, others determine lower, but 16 enough is where I go.
Did you find any of these matches at the scene?
Yes, I found several matches from multiple people at the scene of the crime.
Did you find any fingerprints on the gun?
Yes, I found fingerprints from Jesse Duran, Sydney Park, and Andy Park as well.
I'm sorry, I meant on the gun.
Yes,
Oh, on the gun, okay. Did you find any fingerprints on the shell casing?
yes I did.
Did you find any fingerprints on the safe?
Yes.
Did you attend the autopsy of Sydney Park's body?
Yes, I attended the autopsy the following day.
And what did you learn from this autopsy?
Well, the coroner removed a 9mm slug from the skull of Sydney Park.
What else did you observe?
Well, when I obtained the evidence, the 9mm slug, and I was able to view the autopsy, I was able to perform blood spatter analysis.
Can you explain to the jury what blood spatter analysis means?
Yes, blood spatter analysis is using the directionality and distribution of blood splatter to determine the proximity in which a person was standing. And I also was able to observe the wounds around her head. The wound of Sydney Park was oval shaped, and I seen some stippling patterns around there. So I was then able to do several other tests, firing the gun from both 12 inches, 5 feet, and 20 feet. In doing so, I was able to determine the location in which she was shot, and she was sitting down. I used the height adjustment of Jesse Duran as well to determine that they were approximately 6 feet from each other when she was shot.
Did you conduct any other further testing at the scene?
Yes, I was able to perform gunshot residue testing.
Can you explain to the jury what gunshot residue testing means?
Yes. When a firearm is discharged, gunshot residue is dispersed, also known as GSR. Within these gunshot residues is tiny heavy metals, being lead, barium, and etc. And gunshot residue testing is checking for the presence of these heavy metals on specific surfaces.
Now, did you find any gunshot residue at the scene?
Yes, specifically on Jesse Duran. I performed gunshot residue testing on him, and I was able to determine that there was over 200 tiny particles of heavy metal on his right arm, 75 tiny particles of heavy metal on his t-shirt, and 25 on his left arm.
Now, what did this lead you to conclude?
This led me to conclude that his right arm was further away from both his shirt and left arm. So that makes you assume that his right arm was almost nearly extended when the shot was fired.
I have no further questions.
Before I begin, may I set the courtroom with a demonstrative?
You may.
Your Honor, I would ask you so I can see the demonstrative.
You may.
Jalissa Harris from Defense, may I inquire? Good morning. Now, Dr. Sebastian, I want to pick up where you left off on direct. You were talking about GSR, isn't that right?
That is correct.
Now, you would agree that GSR is a very delicate subject, right?
Very delicate indeed.
And you would agree that somebody could get GSR on them without ever firing a gun, isn't that right?
Yes, GSR is very delicate in nature. So it's possible that you can get GSR from coming into contact with somebody else who has GSR. Most likely police officers from police stations, police cars, etc.
Exactly. So on the day of August 18, 2010, you are aware that Jesse Duran came into contact with multiple police officers that day, correct?
Yes, he was in the presence of multiple police officers. I'm not really sure if they actually contacted each other.
Well, you didn't test for GSR until after Jesse Duran came into contact with these police officers, isn't that right?
Well, actually, that is correct, but I ensured that the clothing was not contaminated, and I performed GSR the following afternoon.
So you're telling us that Jesse Duran came into contact with police officers, but did not in no way get GSR onto him from the police officer? Is that what you're saying?
No. What I'm saying is that the police officer and Jesse were in each other's presence. I don't know if they touched each other to make the transfer from gunshot residue. And I'm saying that I ensured that his clothing was contaminated in order for me to perform gunshot residue testing in my office.
Okay. Now, Dr. Sebastian, I want to move on to your fingerprint analysis that you made. You took fingerprints of the safe, right?
That is correct.
Now, on the safe, you found fingerprints of Jesse Duran,
Correct?
and you also found Sidney Park's fingerprints on that safe, correct?
That is true as well.
Now, you also took fingerprints of the gun, correct?
Correct?
Now, on this gun, you found fingerprints of Annie Park,
Correct?
Jesse Duran,
Correct?
and also Sidney Park.
Yep.
Now, you looked at the gun on August 18, 2010,
Yes, I picked up the gun and put it in the evidence bag.
and you would recognize a picture of that gun if I showed it to you here in court today?
Yes.
Opposing counsel with defense B. Dr. Sebastian, this is a fair and accurate copy of the gun that you saw on August 18, 2010.
Correct?
And this is a fair and accurate copy of the analysis that you did to come to your conclusion to this case.
Yes.
At this time, defense moves to admit defense B into evidence.
Any objections?
I have none, Your Honor.
Dr. Sebastian, this appears to be the exact same portrait that I just handed you.
Correct?
Now, on part one, that was where Sidney Park's handprint was at, correct?
Correct.
And Jesse's handprint was only found,
3 and 4.
yes, on 3 and 4.
Correct?
Now, you found no fingerprints on the trigger.
I did not. The trigger had a tacky surface, so it was really hard to gather a sufficient fingerprint from.
On the trigger?
It was hard to get a fingerprint off the trigger. There was none.
So Jesse Duran did not display any fingerprints on the handle or the trigger.
Well, as you can see by the handle, it's nearly impossible to get fingerprints off that. However, on the trigger, the way it's shaped, it's almost impossible enough in order to do a 16-point match, a similarity. So, no, I found no fingerprints on the trigger from anybody, nor on the handle from anybody.
Thank you. I have no further questions.
I have none, Your Honor.
Anything further from the plaintiff?
No, Your Honor, at this time, the plaintiff rests its case in chief. We request that we have a 5 to 10 minute recess before.
I have no objection to that, Your Honor.
Permission granted, let's take 10 minutes.
Okay.